Hi, good afternoon, everyone. I'm your judge. My name is John Hurley. We're in First Appearance Court. Today is the day the court determines whether or not there is probable cause for your arrest. We're not here for a trial. We're not here to determine whether you're guilty or not guilty. You don't need to tell us what happened. You don't need to defend yourself, make any excuses. You don't need to explain anything that did or did not occur. It's not for today. Save all those issues for your attorney in a private meeting. Understand that everything's being recorded, and if you say something, it will be used against you. You have the right to remain silent. Utilize that right at all times. But if you give up the right to remain silent, begin to speak about your case, whatever you say today can and will be used against you. Also, if you have a private attorney, when you're called up, let me know who that is. We'll contact your attorney and let them know that you're in court. Anything going on? Got it. Okay, may I see Veronica Jackson? Got it.
North Broward, Your Honor.
I'm sensitive.
Hello, Ms. Jackson.
Good morning.
Ma'am, you're charged with aggravated battery. It says you allegedly gave your husband or your serious boyfriend a minor laceration to his leg. So with a kitchen knife. State, do you have any priors on Ms.
Petty
Jackson?
theft, 2013 out of date. Petty theft out of date, 2012. Another petty theft, 2012 out of date. Petty theft, 2004. She had an aggravated battery that was dropped in 2004 out of date. Possession of cocaine, 1990. Petty theft out of 1989 out of Okeechobee. 87 out of Okeechobee, shoplifting. Another shoplifting at 87. 87 shoplifting.
You got it.
And
Is that it?
yes, Your Honor.
Ms. Jackson, are you currently employed?
No, sir, I'm disabled.
Do you have any money in the bank?
You can go back to today.
No, sir, I get disability check every month.
Do you own any land? Do you own a house? Do you own any property?
On the today.
No, sir.
Did you have contact with the alleged victim?
Not on this occasion.
No? Okay.
Yeah, she's been laughing about that for years.
Ma'am, I'm going to set your bonded at $1,500 based on the level of violence, your criminal record, court's concern for the safety of Walter Atwell. I don't want you to have any contact with Walter. Don't call him, don't text him, don't email him. You have to stay 500 feet from him at all times. That's where he lives, works, goes to school. You're not allowed to possess any guns, any weapons while you're out on release. All right, ma'am?
Yes, sir, but Your Honor, can I ask you one thing?
Sure, go ahead.
We live together. This is where I live at. What do I do? Go take my clothes and everything out?
No, what you should do is stay somewhere else. Do you have somewhere else to go?
Yes, sir, but all of my clothes and stuff over there.
Okay, you can do one of two things. You can either send a friend or family member over there to pick up your belongings, or you can call the police to go with you, and they'll escort you over there so you can pick up your belongings, all right?
Yes, sir.
Okay, ma'am, thank you.
Thank you. Am I going to get out?
You have to bond out. Your bond's $1,500, ma'am. Thank you. How about Chanel Mitchell?
She's present at the main, Your Honor. She has declined the services of the public defender.
Ms. Mitchell, you've been charged with a battery, count 1, domestic violence related. Count 2, you're wanted out of another state, and that is for I believe, a fraud. Out of Maryland. You wanted out of Maryland for a fraud, a theft, and they want to extradite. So are there, do we have any priors on Ms. Mitchell?
That's the only thing I see.
Ms. Mitchell, how long have you been in South Florida?
About 2 months, almost 2 months.
Are you, have you moved down here? Is this your new residence?
I'm just visiting for right now.
Okay, and when do you plan on leaving the area?
I was planning on going back a little bit, like before November, like after February.
Do you have any money in the bank?
Yeah.
Okay, yeah, okay. And how much money would you say you have, ma'am?
I have some money, like.
Round
Do you
about.
want it out of $400 or $500?
Okay. And are you currently employed?
No, not right now.
Okay, ma'am, did you have contact with the alleged? Okay, ma'am, it says you were at the Hard Rock and you got slapped in the face. So, or your boyfriend got slapped in the face. And you have a child, right, ma'am?
Yes.
How old is that child?
She'll be 3 this February 24th.
And is she down here with you right now in South Florida?
Yes.
Okay.
The police arrested you.
Ma'am, I'm going to set your bond on count 1 at $1,000. Count 2, you'll be held without bond for the state of Maryland.
Actually, 10,000 looks
Is
like.
it 10,000?
Looks like.
Hamilton,
Ma'am, I've been told that bond's 10,000.
Is that, Sheila, is it?
11.
The
Okay.
bond? Okay. Well, ma'am, now I'm finding out they say it's no bond hold out of Maryland. Now, ma'am,
I heard it was 10,000.
Thank you.
is it, well, can we get it? Okay. I have here 10,000.
That's what it said. That's what I was told too.
It's over there by you. We're
Right.
shipping them out.
Right.
Mr. Addison,
Okay.
page 13.
I'm sure they'll have the paperwork at her extradition hearing.
Right. Okay, thank
Yeah.
you. Page 4, Penton, but Pete is. He on his
I
way.
see bond set at $10,000 on this, hold on 1 moment. Ma'am, hold on. Give me a moment. Okay, ma'am, I just talked to the state of Maryland. You have a no bond hold. I confirmed it over the
Gotcha.
telephone with the clerk up there. It is a no bond. It would have been 10,000 if you would have been caught in the state of Maryland.
Sounds good.
As soon as you get out of Maryland and you're caught and rearrested, it's a no bond hold. But I'll see you in extradition court, and we can talk about it over there, probably on Thursday. All right, ma'am? Until then, your bond's 1,000 on count 1, no bond on count 2. I'll allow you to have contact with Christopher Mitchell. You can call him, you can talk to him. I'm not going to put a no contact on him. All right, ma'am? So your bond's $1,000, but that's really it. Okay? Thank you. Count 1 is 1,000. Count 2, no bond.
What day is it today?
Thank you, ma'am.
Good luck.
What was the bond?
That was my good deed for the week right there.
Thank you.
Calling up the state of Maryland. You know what, though? I don't want anybody to be hung up here if there's
Specifically
a
allowed
mistake.
content?
So that's why I want to make sure we get it right.
Judge, do you have, just as a matter of question, do you have the legal authority to grant an extradition bond?
Yes, sir.
Okay.
Yes, sir. With one exception, a capital offense, I cannot do it no matter what. That makes
Roger that.
sense. But other than that, I can do it. I can even do it if the other state says no bond. However, I don't
Very
do
good.
it in here because I don't have all the information. When I get to extradition, you know, I have all the lawyers and they're telling me what the deal is. So yes, I do graduate on occasion. I will grant a bond even if the judge in the other state says no bond. Unless it's a
There you go.
capital offense, then I have no discretion. So,
Good to know.
okay, now, okay, I'm asking Matthew Hanna. Mr.
President
Hanna,
of Maine, Your Honor.
you're here on a municipal ordinance violation. You want to step forward? MO? Do you know Matthew Hanna? Okay. Come on up. This is the city
I'm
of
here.
Fort Lauderdale. Matthew Hanna.
This is the city of Fort Lauderdale?
I think so. It's,
Mr. Hanna, do you remember me?
Would
I
you
can't-
represent
I
him
can't
at
see
one
that.
point?
He's my soon-to-be ex-cousin-in-law. Or no, cousin-in-law.
Really?
Yeah, as soon as the
Oh,
divorce goes through.
today I didn't know it was going to be family hour here,
Right,
Mr.
perfect.
Shape. But, now, he's got a resisting arrest. Any priors on him? Do we have anything, State?
One moment.
You're not getting a point on this case.
The note here, I made contact with Mr. Hanna on a domestic disturbance, so that could all kind of
It's on the
fits together.
KPS.
Yeah, what's my house?
Mr. Hanna, are you currently employed?
Yes.
Yes, I work at Target.
Okay.
I don't see anything in Broward.
Mr. Hanna, would you like to resolve your case today? Plead no contest?
I've never had any previous. Yes, I would like to resolve it.
You've never
I've never
never been in trouble before.
Never.
Okay, how
This
come-
is the first.
I understand. How come you missed court originally?
I actually thought it was on the 6th,
I
which
got
was
it.
my birthday.
Do you still live on 70th Avenue and Plantation?
Yes.
Is that where you get your mail?
70th. Yes.
Okay, I'm going to give you another bite of the apple. I'm going to release you on your own recognizance, all right? Just
Thank you.
Show up in court, all right?
Okay, so I can leave today.
Yeah, you'll be out of jail shortly, all right?
Thank you so much.
Sir, do you have the rollovers from this morning, the MOs?
Well, you actually have a date. Judge, do you know his court date?
I don't know.
They don't
if
have
you
it
know.
set.
I have a new date
Matthew
yet.
Hanna?
You're not going to have it set yet for
You're
division.
going to have to call the clerk of the court in the next 2 or 3 days.
Status on the,
Looks like February
Is that in
5th.
division?
February
on the
5th.
docket, it says 2/5 at 11.
Okay, the day before my birthday.
Fine.
So,
Matt, you have court
okay.
at
Run, but you change
at
your mind,
Thursday,
man.
no?
Just don't forget to come to court.
It's really
You gave me that, okay.
Yeah. I've looked at Compass and it just looks so.
Look at
She
that.
is on the roll
She
today.
was snapping
One side
the
of the
Hey, on a go.
We'll take care of it.
Ex-cousin. In-law.
I need to see William McDonough, Craig Breer, and Ray Denton. Is that it? Okay. William McDonough, sir, you're here. This is a Hollywood case. We have the attorneys here. It says that Mr. McDonough was, hold on here, drinking alcohol in public. So,
Well, this is out of Dania.
could you tell me, has he been arrested recently?
August of 2014.
For what?
Trespassing, drinking.
Okay, Mr. McDonough, would you like to resolve your case today? Plead no contest, case will be over with.
Yes, I would, Your Honor.
Yeah, if you plead no contest, we're not gonna have a trial, you're not gonna have your day in court, it's over with right now. You understand that?
Yes, I do.
Now, if you can't afford an attorney, I could appoint an attorney for you to help you make this decision. Do you need to talk to an attorney about this, or can you go without an attorney?
No, I believe I can go down to an attorney.
Okay, do you think, I just want to be clear, I'm not gonna change the deal. I mean, if you plead no contest, the case is over with, you'll be out of jail here, hopefully by dinner time. I'm not pulling any tricks on you, but I just want to know, do you think you're being pressured or forced in any way to go without an attorney? Do you feel that you can do this without an attorney?
Yes, I feel that way, Your Honor.
Okay.
I do not feel.
Okay, so you plead no contest, am I correct?
Yes, that's
Okay, I'm
correct.
going to withhold adjudication. Have a nice day, Mr. McDonough. Good luck.
Thank you, Your Honor.
Yes, sir. How about Craig Breer?
Yes, Your Honor.
Mr. Breer, we're here. State, could you tell me whether Mr. Breer's, he says he's worked these cases out. 14.
I did.
Let me give you the, I know, Mr. Breer. I know, you told me that this morning. I want to confirm it. 14-9861 MO10A.
Look at that, only 11 texts in that short amount of time. Should take this.
No,
You didn't work them out?
neither.
Yes, I did.
Not according to saves.
No?
Do you have any paperwork?
Yes, I actually do, and I didn't have it in my pocket when the law enforcement deputy questioned me, but I have it in a Ziploc bag. I held on to it so that.
In your property.
Let me go, time served.
So what we found out is count 2 has been resolved, and that's urinating in public. The count 1, the sleeping on the beach, does not appear to have been resolved. So what would
I
you
did
like to
pay
do?
that also. I would like to plead that out today
All
if I
right.
can. I'd like to
All
resolve
right.
that.
Do you understand by pleading no contest, your case will be over with today? We're not going to have a trial. We're not going to, you're not going to have your day in court. Do you understand that?
Yes, Your
Now,
Honor.
do you need me to appoint an attorney for you to help you make this decision, or can you go without an attorney?
I can go without an attorney, Your Honor.
Okay. How do you plead, sir?
No contest.
I'll withhold adjudication, sir. Thank you. Good luck.
Thank you.
Yes,
Thank
sir.
you. Thank you.
All right, Ray Denton. Mr. Denton, you're here for panhandling in traffic, and I know you've been in here a few times before for the same thing at the same place, and I recognize you. So, state, when was the last time Mr. Denton was in here? Mr. Denton, the last time you were here, we asked you to stop panhandling in traffic, and apparently that fell on deaf ears.
January 16th,
Okay.
municipal ordinance solicitation on the roadway.
That was
It's
probably
ROR.
at the same location.
Broward and Andrews.
Yeah, same place. Broward and Andrews. Go ahead. What about the time before?
November 13th of last year.
Okay.
Solicitation on roadway, Broward and Andrews.
Same thing, same place. You know, I've asked you, you know, sir, I mean, you wouldn't be in jail if you just quit doing that. I don't quite understand why you keep going out, because you know you're going to get arrested. I mean, the police watch that intersection. I don't get it, but that's, okay. Anything before that?
Yeah, Judge, October 19th, 2014.
10,
Yeah, October 19th, 2014, municipal ordinance violation, panhandling again.
same place?
Thing, Judge.
Same location.
Then September 27th, it's like pedestrian soliciting a business in the roadway.
Where was that?
I don't have where that was, but
You know, and the kicker to the whole thing is that I'll read the last line here. It says he's homeless, or he's at large, that's what it says here. He's at a shelter, maybe up in Pompano. Now, let me read the line. Defendant is aware of homeless outreach and has refused all assistance. So they keep telling him, sir, we'll take you to a homeless shelter, and he doesn't want to do it. So, all right, now, are you employed, Mr. Denton?
No, sir.
Do you have any money in the bank?
No, sir.
Okay. All right. So he doesn't have the money to bond out. This is the 1, 2, 3, 4. It looks like the third or fourth time he's been arrested for panhandling at Broward and Federal. So, do you have any comment, Mr. City Attorney, about
Judge Don Lonray, City of Fort Lauderdale. I'm looking for 60 days, Broward County Jail. He's about every month. He gets arrested, sometimes twice a month, to the point where he doesn't care, Judge.
No,
He doesn't want to stay on the road. I can give him somewhere else to stay. And I don't think probation's going to work or anything else. I think
Right.
it's going to have to be jail.
sir, I'll offer you 60 days in the Broward County Jail credit for the night you have in, or I'll give you a bond and I can appoint an attorney for you, and you can have your day in court, and maybe you can go to trial and win the case. So it's up to you. What would you like to do? Would you like to get 60 days in the Broward County Jail, or would you like me to give you a bond, and then you can talk to an attorney about how to resolve this case? What would you like to do?
Attorney, please.
Okay, I'm going to appoint Mr. Stephen Shate. Sir, I'm going to set your bond today at $1,000, and I'm setting it based on your 1, 2, 3, 4. This is your fifth arrest in the last, 4 months. So, same thing, same place. And I'll appoint Steve Shate to represent you.
All right.
Thank you, Mr. Shate.
Thank you, Judge.
Hey, Denton.
Is the petition?
Yes.
Is that you?
That's your defense. Make sure. Good luck.
Now, I believe, we have one more. Mr. Shate?
Do you have an attorney?
James Bonin?
He's present at the main, Your Honor. He's here on a second look.
Yep, got it. Alcohol consumption. This looks like a City of Fort Lauderdale case. There's got to be another matter.
I had a VOP, sir, but it's been resolved, reinstated, and everything.
Okay. He's got 49 days, and I'm just gonna. So, would you like to plead no contest to this alcohol consumption violation? The case is over with today.
Yes, sir.
You're not going to have a trial. We're not going to appoint an attorney. Well, no. Let me stop that. You're not going to have a trial. You're not going to have your day in court. Do you understand that?
Yes, sir.
Now, would you like me to appoint an attorney, if you can't afford one, to go over this matter and discuss it with you, or can you plead no contest without having an attorney?
No, sir. I'm cognizant of what you're saying, and I understand my rights, and I want to go ahead and resolve it today.
Do you need me to give you an attorney to help you make that decision, or can you go without an attorney?
No, sir. I can go without an attorney.
How do you plead, sir?
I plead no contest,
I'll
sir.
withhold adjudication. Thank you, Mr. Bonin. Have a nice day, all right?
All right. Thank
Good
you,
luck.
sir.
Good luck.
All right.
Okay. Okay,
How much is
I think
it?
we're done. Okay? Thank you.
Thanks, thanks, Judge.
Just give numbers, you don't need. Oh, I don't know if you're doing
Miko.
that, I'm asking you if you work, you told me yes.
Jerry Micko?
That was,
President DeMane, Your Honor, he's declined the PD. Guy
This is,
Seligman is
well,
his
it's actually
attorney.
Castillo. He wants it for tomorrow.
Got it. Reset for what, tomorrow afternoon or tomorrow morning? We're gonna reset this. Your attorney was in here, Rick Castillo. We're gonna reset this for tomorrow morning, all right, sir?
See you tomorrow.
that's the question I don't ask. He wants it for tomorrow
You ready to go?
morning. Fine with me.
Spanish?
Page 9, main jail, Perez Lopez.
Señor Perez Lopez.
Sir, do you swear or affirm to translate from English to Spanish, Spanish, English truthfully to the best of your ability?
I do.
This is a traffic ticket. I don't know why it's on our... It's an ad charge of a traffic ticket,
Wait,
right?
who's this?
This is Perez Lopez.
No, it's, no, I have all the counts. DUI,
Tengo 9 cargos.
DUI enhanced breath, operating without.
Maybe something got stuck to another page here. Hold on. You know what? I don't know. I don't have those other counts. I mean, I see them, but I don't have a cover sheet for them, so I'm going to have to get a cover sheet. Sir, you've been charged with DUI,
Señor, se le acusan de manejar bajo los efectos,
DUI with an enhanced breath reading,
manejar bajo los efectos y haber soplado más allá de .15,
no driver's license,
manejar sin licencia,
disobeying a stop sign,
haber desobedecido una señal de tránsito,
disobeying a red light,
haberse soltado semáforo en rojo,
disobeying driving on the wrong side of the road,
manejar en sentido contrario,
disobeying a traffic device,
no haberse atenido a un dispositivo de tránsito
improper stopping.
y haberse parado indebidamente.
The court finds probable cause.
Existe motivo fundado para cada cargo.
State, does this defendant have a criminal record?
Tiene antecedentes, abogado fiscal.
I get a hit out of Mississippi, arrest in 09 for DUI and profanity, drunkenness in public, and an arrest in 2011 for disturbing the peace.
En Mississippi tengo cargos en el 2009 y en el 2011. Manejar para los efectos en el 2009 y causar un alboroto en público en el 2011.
I have no disposition, but I also have no license or ID information tying into Florida.
Driver's license out of another
Tiene
state?
licencia
Well, I
en
wouldn't
otro
know
estado. No sé, dice el fiscal.
No.
What do you take?
I can tell you the DUI in Mississippi also had a charge of no driver's license or expired driver's license.
En el DUI, manejar para los efectos de 2009 en Mississippi, también
Yes,
estaba
but
manejando sin licencia
hypothetically
válida,
speaking,
licencia vencida.
I know there's no disposition. If he didn't go to court, there's no social security number. There would really be no way to track him.
Pero no hay manera de averiguar realmente qué pasó, cuál es el desenlace de ese caso, porque no tenemos número de social security
So you were injured because
y
of
otros
the
datos necesarios para averiguar.
No, they're talking to him now.
Here, the middle two suites, the two middle aisles, sir, down the middle, sit next to that. You can sit right here, come here.
You can sit right here.
Okay.
Right here. Yeah, come on.
Sir, are you currently employed?
¿Tiene usted empleo en estos momentos, señor?
Sí.
Yes.
What type of work do you do?
¿A qué se dedica?
Remodelaciones de baños, pintura.
I paint, I remodel bathrooms.
Do you have any money in the bank?
¿Tiene dinero en el banco?
No.
No.
Okay. How long have you lived in South Florida?
¿Cuánto tiempo lleva en el sur de la Florida?
2 años, casi 3 años.
Almost 3 years.
Okay. Okay.
That's very distracting.
I will. Sir, I'm going to set your bond on count 1. You have no driver's license, and based on the level of alleged level of intoxication, the facts of the case, I'm going to set your bond on count 1 at $500, 2 $1,000, count 3 $1,000, and you can bond out of jail, sir. Thank you.
Sí, debido al nivel de alcohol en el sistema y los hechos, se fía fianza en $500 cargo número 1, 1,000 en cargo número 2 y 1,000 en cargo número 3, 2,500.
Thank you.
Gracias, señor.
Anyone else?
Okay.
Does he get the warning about 10 days to get a restricted permit?
He doesn't have a license to begin with, so
No tiene
I think it's a
licencia.
moot point, you know?
No hay posibilidad de
Okay.
sacar licencia.
¿Puedo hacer una pregunta?
What? Yeah, I didn't know. I didn't have it.
Voy a pagar con bon.
Sorry.
¿Puedo pagar con bon?
¿Puede pagar cómo?
¿Qué puedo hacer? ¿Puedo pagar fianza o no?
Can I pay the bond?
Sure.
Son 2,500, señor.
Thank you.
Gracias, señor.
Pero tengo fiancista.
Thank you.
Gracias. ¿Alguien más necesita intérprete? ¿Alguien más en español?
Do you want to do it in Spanish? Venga. We have one taker, Your Honor.
Someone decided to.
What is your name, sir?
Coco Vargas?
Vargas?
Is that you? No, Leandro Monte. Oh,
No, espera.
sorry. I have another.
What is your name, sir?
Señor, su nombre y apellido.
Leandro Mompi. Page 10 of the document.
was reinstated December
10,
22nd.
Alberto Coco.
No.
No, it's not him.
This is
Leandro Mompi.
Mompi. Sir, you have possession of cocaine,
Se acusan de posesión de cocaína,
no driver's license.
Over there.
manejar sin licencia,
Speeding, open container,
exceso de velocidad,
expired driver's
manejar
license.
con un envaso abierto, manejar con licencia vencida.
Court finds probable cause.
Si hay motivo fundado en el expediente.
Sure, you have a. I'm going to set your bond on count 1 at 1,000,
Se fía fianza en $1,000 en cargo número 1,
and I'm going to set count 2 at $500, sir.
500 en cargo número 2.
Count 6 is failing to show up in court. That's 500. Your total bond's 2,000. Thank you.
Número 6, por no
Thank you,
haberse presentado en corte, otro 500. Tiene un monto de 2,000, señor.
Thank you.
200.
2,000. Gracias, señor. It's not all.
Good luck. Thank you.
Okay. Jose,
Medical reset.
Okay, thank you. Let's do Wednesday PM on this gentleman.
I'm still in the middle of. You gonna be home later?
Oh, I'm sorry, Your Honor. He is here. He did show up.
Okay, well, he got better quick. So,
He is present at the main, Your Honor.
All
I
right.
did not get a chance to interview him.
sir, Mr. Penton, you're charged with aggravated battery on a pregnant female, resisting arrest without violence, count 2 and 3, count 4 is criminal mischief. I find probable cause. And okay, State, do you have any priors on this gentleman?
Grand Theft Auto 2011.
Okay, anything you want to say on behalf of this defendant, Mr. Miller?
Your Honor, is there any evidence in the probable cause affidavit to indicate that he knew or should have known that she was
I'll read
pregnant?
it right here. I'll read it right here. The victim, it's very short. She advised she just found out she was pregnant with defendant's child. Once the victim told the defendant, he became enraged and started a verbal argument with the victim. Victim stated that she was gathering her belongings. Defendant struck her several times in the stomach with a fist, and you know what? I'm not going to read that. It has a quote from him. I think it's too charged to say it, but you know, unless he wants me to say it. But
To hear it.
you know, I think it's probably too over the top for me to say. So, go ahead, ma'am. Any priors? I mean, anything you want to add?
Yes, Your Honor, I did speak with the innocent victim. She indicated that the defendant needs help, that he was taking medication for a specific mental health issue.
Okay.
And her primary thing was just that he needs help.
I got it. Mr. Miller, do you have anything to add at this point?
I'm sorry. I didn't hear that last part. Her pregnancy was what?
What?
No, I was just told that by
This
the
was Saturday to this morning. I
victim's
had to reset for the
advocate that
afternoon.
he was on medication at the time and she thinks he needs some mental health help. That's it.
Oh.
Okay?
Okay. Well, Your Honor, like I said, did not get an opportunity to interview him. I have no objection to the court asking him about his ties to the community.
Sir, how long have you lived in South Florida?
All my life.
Are you currently employed?
I work with my father.
What type of work do you do?
Lawn service.
Okay, do you have any money in the bank?
No, sir.
Okay, do you own land or property down here in South Florida?
No, sir.
Who's going to help bond you out of the jail?
I'm gonna have to sit, sir.
Okay, I'm going to give them to you with monitor. Sir, based on the facts of the case, level of violence, what appears to be your anger directed toward Miss, I'm not sure of her last name, you know, Charles, and the specific violence toward the unborn child, and then allegedly your statement, which is included in the affidavit, gives the court great concern not only for her but the unborn. So I'm going to set your bond on count 1. That bond's going to be $20,000. Count 2 will be $1,000. 3 will be $1,000. Count 4 will be $500. Your total bond today is $22,500. Also, the court notes your criminal record, and the court's concerned for the safety of the alleged victim and the unborn child. Discussed in the probable cause affidavit, I'm going to order pretrial release with the GPS monitor. I'm going to waive the cost of that monitor. Court will order you have no contact with Miss Ashley Charles. Don't call her, text her, email her. No notes, no letters. You must stay 500 feet from her at all times. You're not allowed to possess guns, firearms, or ammunition while you're on release. Thank you. Yes. Stephanie Roser?
Your Honor?
Yes.
We still had Adam McCarthy from this morning.
All right.
Okay, let me just take care of Roser.
Ryan Facility, Your Honor.
Got it. Hello, ma'am. You are charged with DUI property damage, license suspended. DUI, first offense, failed to submit to, I'm not sure what count 4 is. Let me look here. Failed to submit to accident, I don't know. Failed to show insurance, I think, right? And then count 5, failure to display registration. 6, careless driving. Ma'am, I'm going to find probable cause. I think it's already been found by another judge. And I'll find it also. Now, let me ask you, ma'am, you've been in jail now, what, for a couple days?
Yes, sir.
How come you've not bonded out of jail yet? The bond's only $1,500.
My mom didn't have any collateral
Oh,
for
okay.
$15,000 and $2,000.
Okay. Now, ma'am, how long have you lived in South Florida?
My whole life.
It's a recent.
Okay, and are you currently employed?
No, sir.
No? Are you in school?
About to be.
When was the last time you were employed?
A couple months ago. I worked at Toss in the Boca Mall.
Okay, do you have any money in the bank?
I don't.
Okay, do you have children?
Patrice.
I have one.
How old's the child?
15 months.
Does the child live with you, ma'am?
He was with my mom. I'm going through the DCF case to get him back now.
Okay.
And I had my prescription meds in my purse. That's why they said it was a DUI.
You don't need to tell me about that, ma'am. Really, save that
Okay.
for your attorney. There was a crash in Coconut Creek, allegedly. Okay, let me look here. See, do you have any criminal record on Miss Rozier?
One moment, Judge. Let's see. Yes, that's her. I don't have anything out of Broward, Judge.
No?
No.
Okay. Let me just look here.
And after the arrest, I'm not gonna wait, it's a cross arrest anyway, I'm not calling the victim. Can you just
Well, no,
leave
it's
it
not.
there?
It's not a cross
Ma'am,
arrest.
you have a failure to appear
There's
in
no-
court
they
in
screwed up. There's no
September
injunction
of
on it.
last year in West Palm. So, ma'am, I'm going to let you bond out today. Your bond's going to be $1,000 on count 1. Count 3 will be $500. You can bond out, ma'am.
Just
Remember,
yesterday,
you only have
February
10 days to get a temporary driving permit from your arrest. So if you don't get out within 10 days of your arrest, make sure you take your release documents to the Department of Motor Vehicles the following day, and they'll give you a grace period. They'll extend it because you couldn't get out of jail. All right? So go ahead.
So if I bond out right now with the $200, I don't have to worry about the warrant?
Well, what do you mean don't have to worry about what?
I'm
warrant?
saying if I bond out, are you still going to hold me because the warrant in West Palm Beach?
Oh,
Or am I okay?
I didn't even know you had a warrant in West Palm.
You just said the failure to appear.
Well, yeah, but I don't know if it's turned into a warrant yet. It's on your driving
Oh.
record, but I don't know if Broward County's holding you on that.
Oh, yeah, no.
So
Okay.
if they're
So
not
I'll
holding
bond
you,
out,
you'll
I
probably
think.
get out of jail, all right?
Okay, thank you.
Okay, ma'am, thank you. Yeah, we didn't hear from, do we happen to know William Kuhn's telephone number? Does anybody know it? William Kuhn? C-O-N-E, William Kuhn. May I see Adam McCarthy, sir? You're already out on a domestic battery, I believe the same alleged victim, right?
Yes, sir.
You don't need to say anything. I left a message with your attorney, Mr. William Cohn, Bill Cohn. He knows you're in custody. I talked to his secretary, but right now he's not available. Sir, you were on release not to have any contact with Ms. Morissant. Allegedly, you had contact with her, and when you had contact with her, got into another altercation with her. So I'm going to set your bond today at $10,000 on count 1. Count 2, I'm going to set that bond at $5,000. Your bond today is $15,000. And I'm going to revoke your pretrial release on 14009089. MM10, you're going to be held without bond. Thank you, sir. Have no contact directly or indirectly with Sergine Morissant. You must stay 500 feet from her at all times. Thank you.
Okay. Good luck.
You see Paola Beltran?
Medical reset.
Okay, we'll set her for Wednesday PM.
Listen, what were the bonds on the new charges? 10, thank you.
John Veer Rodrigue, Richard Dubois. Rodrigue, you have a misdemeanor that's a license suspended $500 warrant. Thank you, sir. How about Richard Dubois?
Good luck.
Sir, violation of probation on a felony. You'll see your judge on the 6th. Thank you. No bond until then. Now see Alberto Coco Vargas, Marlon Hamilton, and Sugar Ray Allen.
Mr. Coco Vargas is president of Maine, Your Honor.
Sir, your bond has been posted by a signature bail bond. You'll be out of jail shortly. Thank you.
Good job. Good luck.
Marlon Hamilton.
Your Honor, Mr. Hamilton is advising that he resolved his case. He's currently serving a 364-day sentence.
I'm going to no bond on both of these, so I'm going to let him go to his trial judge.
He said he already did. And
Sugar Ray is a medical reset, North Broward.
We're not there yet.
What about Hamilton? Okay, but do I release him ROR? I don't release him ROR. I'm just leaving it no bond. It'll be taken care of. There you go. Sugar Ray. What about Sugar Ray Allen?
North Broward medical reset.
Got it.
Your Honor, I just asked the court to make a PC determination.
I do. I find probable cause Wednesday PM. You like that, huh, Mr.? All right. I don't think Mr. Miller gets that kind of subtle humor, but okay. Okay, Mr. Miller, may I see Broderick Bacon?
He's on loan.
He's on loan?
Med reset.
Well, how many days has it been now?
I think it was from yesterday.
I've got 3 days now. This is the 4th day.
Since it's a PBL, though.
Yeah, okay. So I'll set it for Wednesday PM, all right? What about Aki Addison?
Your Honor, he's in courtroom 6870.
Okay, I'm going to find probable cause. Bond, count 3 is 1,000. Okay, I think that's
we got 2 more. Edwards and Etienne.
I see Angeles Etienne.
Now,
President of Maine, Your Honor.
Your Honor, I provided a supplement. The issue that the judge had over the weekend was that there was no indication how the detective knew that Mr. Etienne was involved in the offense. The supplemental portion is the first paragraph provided in the supplement, Your Honor.
Right, I have here during an interview with Angeles Etienne and Milseti Jobed on an unrelated case where the two fled from North Lauderdale deputies, high rate of speed. The two confessed to taking part in the armed robbery of the victim on January 21st, 2015. Witness who's the girlfriend, and it goes into more detail, but it says here that they planned to rob a unsuspecting pizza delivery driver in North Lauderdale. From Jano's Pizza Restaurant, they ordered pizza and chicken wings. And it says the three suspects surrounded the victim, pointed what appeared to be a gun. The victim suffered multiple lacerations. Some needed stitches, and it was across his right eyebrow. So,
Your Honor, for proof evident presumption grade, well, obviously PC also, I would just, proof evident presumption grade would obviously encompass PC. I would just argue that the supplemental information, his admission does satisfy the identification portion.
so you're seeking to foreclose bond and release conditions?
Yes, Your Honor.
So there has to be a finding of proof evident presumption grade today?
Yes, Your Honor.
Sir, allegedly, this defendant admitted to it, confessed to this crime?
Your Honor, that in and of itself is not enough. I would argue that there's false confessions every day, and that would in and of itself not constitute enough to hold him proof evident presumption great. He would be entitled to a bond, but I don't know what the rest of the case is. I don't have those facts in front of me.
Sir, I'm going to today find there is proof evident presumption great, and I'm going to order the defendant be held without bond. The defendant's not allowed to have any contact with Everett Markison, and the court bases the finding on not only the original affidavit attached here too, but the supplemental affidavit, which says that he and a co-defendant confessed to the crime, and also there was a witness, a girlfriend of
It's a third
someone who,
co-defendant.
there was a third suspect or a third defendant, and that third defendant's girlfriend also told about how the robbery was planned and how the defendant had confided in her specific details about the crime. And so not only do we have this defendant admitting to a third party as to the robbing of the pizza delivery driver, but we have the defendant allegedly confessing to it. So,
And Your Honor, there's one other matter with pretrial.
go ahead. I'm going to go ahead and I'm going to revoke the pretrial status on. I'm going to go ahead and revoke the pretrial status on 14-1023 CF10 for burglary and grand theft. Thank you, sir. You can be held without bond on that case also.
And we have Travis Edwards.
Okay, so can you make sure this paperwork stays without him?
What I would ask you to set a bond pursuant to Preston. I was doing something else. I missed that on Mr. Etienne.
Okay, pursuant to two cases, the Preston case and the Keel case, K-E-E-L, out of the 4th District Court of Appeal. The court is of the position and the opinion that where the state of Florida, the prosecutor, has moved to foreclose bond and release conditions on a first-degree felony punishable by life for a capital offense, this court is without discretion at first appearance to give any type of bond or release condition, and that the defendant's only manner of relief is to have a full-blown bond or Arthur hearing before his trial judge. Thank you. Defendant will be held without bond. Okay, so, Travis Edwards, please.
Yes, he should
Ryan
be
facility, Your
Paul
Honor.
Ryan. Your Honor, if I can
That's
give,
Ryan facility.
before we move forward, if I can give the court a little backstory, because, and Sheila, I don't know if you can help me with this. We're here on count 2. Count 1, what happened was he came through originally robbery with a weapon. Deputy Rodriguez was actually present in court for this case, Your Honor. The state sought to foreclose. In the packet I gave you, the first 2 pages are the probable cause affidavit.
Right.
And the state sought to foreclose for robbery with a firearm.
Got it.
The court found only, at that time, on one count, only found probable cause for robbery with a firearm and set bond at $25,000 and pretrial release with a GPS monitor.
Right.
What has happened since then is the state filed charges. They did a change of charge because it came through as a robbery with a weapon to robbery with a firearm and added a second count of robbery with a firearm. Now, even though we're really on the second count here, the court needs to make a determination on both counts. As an officer of the court, I will tell you that, Your Honor, for count 1, did take into consideration the state seeking a foreclosed bond, as I stated earlier. My argument today I would agree count one should be $25,000 pretrial release of the GPS monitor. Because the court did take into consideration robbery firearm. Now, I would be seeking to foreclose on count two, and the reason being is because, Your Honor, the state has provided more information than the court than was present to the court at that time, namely the transcribed victim statements, victim/witness statements.
Okay.
So that is that would be the state's posture at that time, that even though count one would necessitate setting the same bond and release conditions,
Right.
that it's in this court's discretion, but I would argue that the court can consider the state moving to foreclose based on additional information being provided.
When the court,
Your Honor.
Well, let me just make sure we're clear. When the court decided initially that there was not proof evident presumption great but standard was met, this court had a certain amount of information. Now we're beyond that, and the prosecutor has provided, a great deal more information regarding the same alleged act. So, what would you like to say, Mr. Miller?
Your Honor, I'm going to object strenuously to the court finding proof evident presumption great on count two. The mere adding of a charge does not warrant the court's reconsideration of a finding of proof evident presumption great. That is not enough for the court to find proof evident presumption great. Just because they gave you the transcript doesn't mean there's new information. I haven't read the transcript. I don't know what's new, but I do know that the detective was here. He testified at length before the court. The court found that 50% of the people in the area where he was found fit the description of the defendant, and that there was not proof evident presumption great. Furthermore, there was the argument made by me that the alleged firearm was said to have had a orange tip on it. I argue that meant it was a toy. The court said something about reading an article in the New York Times about gangs painting their guns orange to avoid being shot at by the police. Your Honor brought that up. I've since found information that debunks that entire story. Your Honor, there is no proof evident presumption great. If you're leaning towards finding proof evident presumption great, I would ask the court to give us time to review this alleged transcript before making a final decision.
Your Honor.
Let me look. Okay, let me look. Okay, so, Steve, what's
Your Honor,
position?
my response would be, it was not a detective here. It was the arresting deputy.
Okay.
And this was the day after. And I know Mr. Miller's rolling his eyes, but you know what? It's a fact of the matter that a detective does more investigation than just the initial deputy. There's additional reports provided by other. The deputy didn't take the sworn statement from these witnesses.
What about Mr. Miller's point? It's basically the same charge. It's tweaked a little bit from the initial charge. Mr. Miller, and I don't mean to put words in your mouth, but you're arguing that the state can't get two bites of the apple on this case? I mean, if it didn't work the first time, and there's no change in circumstance, can you bring this defendant back to have another bond reviewed on the same basic?
If it was only one count, I would agree, but it's not.
Okay, Your Honor, I'm first of all, I couldn't have said it better myself. I probably would have been better to sum it up that way, and I'm just going to discount the state again because adding charges does not give them a second bite at the apple. Preston is all over that, Your Honor, that just the filing of information, the filing of an indictment does not in and of itself create proof evident presumption great. Preston is all over that.
I 100% agree. It has to be based on what the information provided. It's for the same reason that, and as I've done in here, Your Honor, where let's say someone gets arrested for armed burglary, and we add a count of robbery firearm, that I just don't hand you an information, Judge, and say, see, you found proof evident presumption great last time. We filed this as charged, so find it again. I give you a report so you can see what your findings were based on. That's why I'm providing additional information.
Let me say this. I mean, I know that the state can have different charges added on from the same set of circumstances. But, and I've, in here in the past, found that there's been, you know, someone could, you could have an aggravated battery, and then the next day the person dies, and you bring the person back on a murder charge. So you could, and it's the same set of circumstances. The question becomes is,
Are there new facts?
well, is it substantially the same charge? It's the first charge was what, robbery with a firearm, and now it's robbery with a weapon?
Yes, Your Honor.
Other way around.
No, it was robbery with a weapon, now robbery firearm. The court did consider the state's argument for robbery with a firearm.
Judge, I can make this easy.
Go ahead, sir.
The hearing from January 9th, Mr. Atria has a copy of it. You can just pop it right in and watch it.
Well,
and you'll see exactly what you considered when you found that there was no presumption grade.
Here's the issue. Here's the difference. We're dealing with is it whether or not it's.
I'm not disputing that Your Honor did not find proof evident presumption grade for one count of robbery with a firearm at the first appearance.
Right.
Not disputing that at all. I'm not disputing the reasons the court had for not finding proof evident presumption grade. I'm merely making the argument that we have an additional count. He's before Your Honor in the first appearance on an additional count. I'm following the rules of criminal procedure. It says that the court must make a determination if he's to be held. I'm not even arguing it on count one, because count one did come through before you, Your Honor.
Right.
Judge, the only difference here, I know,
semantics is what it is. It's semantics.
the difference here is they've added an extra victim.
Right.
Okay, both victims were listed in the probable cause affidavit. Both victims were made known to the court at the time of the original hearing. There is no new factual information being provided by the state.
Actually,
this charge is about a different victim or the same victim?
Well, actually, no. And I guess if you want to listen to it,
actually, I think that weakens your argument if it's a different victim.
And actually, and that's the thing. If you want to listen to the CD, we can listen to the CD. But I don't necessarily remember. I could be wrong, but I don't remember him say the deputy saying that something was stolen from both of them. I just remember. I know there was a male and a female, boyfriend and girlfriend, and something was stolen from him. And that's why there was only one count.
This is like a morass of, I don't know.
Well, I have the original probable cause affidavit.
Is it a different victim?
So there's both Tyler McLemore and Jessica Merhudio were listed in the probable cause affidavit. Now they've gone and filed an information listing them both as victims. But there's no new facts.
Your Honor, it does.
Just because the state's overcharging doesn't mean you have to find proof evident presumption grade.
It does list them both, and my mistake. It does mention in the probable cause affidavit that they causing them to give their property. So it does. It's my mistake. It does mention the original PC that there were two victims and that both gave their property.
Okay. I think that I got to be Solomon right now, and I'm not going to give him a bond on count two. I'm going to let count one stay as it is. All right?
Your Honor, we're objecting. This is absolutely, the court is acting with outside the scope, outside of its jurisdiction. You've already found proof evident presumption grade. You are now you've already not found proof evident presumption grade, and now you're finding proof evident presumption grade based on the facts. The only thing that's different is the amount of time that's elapsed since January 9th.
He's not finding proof evident presumption grade on count two.
He said he's not going to give him a bond.
No, I said no.
That's what you said. You're not giving him a bond on count two.
I misunderstood. Hold on. Now,
it's not a case from the judge. It's okay.
So what I'm going to do is I'm going to give him a bond on count two of I'm going to give him a bond on count two of $10,000. Count one's $25,000. All other release conditions remain.
So obviously, you don't even have to add the pretrial because it's the same
done.
case. Yeah.
Bond is $10,000.
Thank you, Judge. I appreciate that. We have one more case on the second look.
I thought my preface is I had to be Solomon. What I meant was in the grand scheme of this whole thing, I had to be fair, and I felt the man was getting a double whammy on this. So That was what I
No.
was trying to do.
No.
Normally, when
Sometimes.
we hear a judge invoke Solomon, it means he's going to split the baby. So.
Well, I was trying to be, on one hand, I realized the alleged crime, but then I think that if I held him no bond, I'm giving him a double whammy. So, all right.
Thanks, Judge.
Yep.
Appreciate that. We have one more case. It's a theft charge. Guy's been in custody for 6 days for a $250 bond.
What's his name?
Come on up.
Jeremy Brown.
I don't have Jeremy
I don't have
Brown.
He's on the second look docket, Judge.
No, he's not.
It doesn't show
Case
on the
number-
second. It doesn't show it.
Am I looking at the wrong date? Today's the 3rd, right?
Yes.
Yeah.
He's not on the.
It might have been deleted and I didn't get that docket, but he's...
Don't have him show.
I don't have him. Jeremy Brown. I don't.
Oh, theft.
So let me look something up here.
I have a case number.
Hold on, I'll get that from you. Give me just a quick moment here.
I'm trying to get First Step Sober's house and number.
Oh, yeah. He asked me to, if the court's not going to resolve the case, if you would consider pretrial release, custody to custody to First Step Sober House.
His last name is Brown.
Yes.
Yes, Your Honor.
What's the community case number?
001 214 MM10A. That's Mike 10 Alpha.
That's Jeremy Brown?
Correct.
Okay. Okay, give me the case number one more time.
15001 214 MM10A.
And Your Honor, wait, I think this was.
Yep, this is a petty, let me look at
It was at a restaurant, I think.
It said at 2:50.
That's correct.
Yeah, you said it at.
Last year, failing to pay a
Exactly.
restaurant, disorderly conduct. Last year, trespassing, resisting arrest. And he had allegedly gone to yeah, someplace Dirty Blondes or something. I don't know what that is. $35, food and drink. Said he was intoxicated, taken into custody. All right, sir, I'm not going to do anything about it today. I'm not going to do custody to custody. I'm going to let you, if you want to go into the alcohol program in the jail, I'll do that for you. You want to do that?
Yes, Your Honor. Well, if you can give us an order for that, I
will.
appreciate it.
Sap?
I'll sign
Thank
that.
you.
Thank you.
Yes, please. Thank
Thank
you.
you.
Sorry
Yes.
about that, Drew.
I see, may I see, hold on. Donald Jordan? Do you have Donald Jordan over there?
Ryan Facility, Your Honor.
Got it. Mr. Jordan? Sir, possession of cannabis. Are you being held on something else, sir?
Not that I know of, sir.
Well, you've been in jail 33 days on a misdemeanor. I'm just wondering what was causing you to stay in jail so long? Do you have a violation of probation or a felony case or something else?
Mm-hmm.
Hey, you've been in 33 days, right?
He's got,
Yes.
Your Honor, he was arrested on violation of pretrial release warrants. He's state sentenced.
Dale, I need you,
dwelling
Dale.
and grand theft.
Yeah, okay, well, I knew that there was more to that story. Sir, would you like to resolve your possession of cannabis today so you can begin your state sentence? Mr. Jordan, if you want to plead no contest today, your case will be over with today. There'll be no trial. We're not going to appoint an attorney. You're not going to have your day in court. You plead no contest, the case is over with, and you can begin your state sentence. Do you want to do that?
Yeah.
Is that what you want to do?
No. No.
You don't want to do that?
I
want to resolve it.
See that top case right there.
Mr. Jordan, how do you plead to this charge?
Sheila, tell him I'll do the order.
Okay, sir. I'm going to accept that. I'm going to withhold adjudication so you can get your prison sentence started. Good luck. Thank you. All right, what about Jason O'Mara?
Have a seat there.
Conti, Your Honor.
I know, I'm doing something else.
Jason O'Mara? Hey, sir. How you doing?
Yes, how you doing, sir?
Good. Mr. O'Mara, you're here for petty theft. Sir, how come you haven't bonded out of jail yet? You've been in, oh, you have another case pending?
Yes, sir.
What's that for, the other case?
Grand theft out of Marion County.
Okay, I'm not going to take any action today. I'm going to let you go see your trial judge. Good luck, sir.
All right, thank you.
Yes, sir.
Just have a
How
seat
about
for a second.
Susan Beck? Ma'am, you've been in jail 12 days now for suspended license. Is there another case holding you, ma'am?
Yes.
Okay. All right, ma'am, I'm going to send you to your division judge. Thank you, ma'am. Okay. Now. Okay. Okay. Maurice, oh, we took care of that, right?
Yes.
Jefferson's done. How about Alexander Young?
It's a 30-day, should be in safes, is being filed.
Hey, Mr. Young.
What? How you doing, Your Honor?
Good. Just give me a quick moment, sir.
Odyssey.
Yes, sir.
What do you say about Audrey? She wants to know.
It's a 30-day, it's on Odyssey that we filed.
The one before that.
We took care of it this morning.
Okay, Mr. Young, we're here on case 15-00036 CF10. I'm looking here, State of Florida filed a formal charge against you. It is February 3rd, 2015. The State of Florida filed a burglary charge on you. I'm going to pull that up for you right now and read it to you. This is the State of Florida versus Alexander Young. Count 1, burglary of a dwelling. Count 2, grand theft. That's a formal charge. It's no longer just an arrest type charge. This is a formal charge against you. Signed and sworn to by Mark Horn, State Attorney's Office, February 3rd, 2015. Let me ask the defense. Mr. Atria, do you have any issues with this?
We do not.
Okay. Mr. Alexander Young, today this court will deny the motion to release you on your own recognizance. You'll be held on all previously set bond and release conditions. Thank you, sir.
You're the last guy.
You go.
That's it, I believe. Wait, what's your name, sir?
Oh, Jaquez Dowling, sir.
Last name?
Dowling, D-O-W-L-I-N-G.
Huh, I don't know where this came from. I don't have it.
It got lost in translation.
It's on the second look docket, sir.
I don't have it.
Theft and resisting recovery. And I can tell you, it's a misdemeanor, but he's got 2011 battery, resisting without violence 09, marijuana 2011, 2012.
So I'm not going to take any action on your case. I'm going to let this go to your division judge. Thank you. Thank you, sir.
John.
Is that a wrap?
Yes, sir.
Okay, that's it. We're out from room 235. Have a very nice day. That's a wrap. Thank you.